Okay, well, I just want to say welcome to the people who are showing up. We'll wait a couple more minutes to make sure that everybody gets a chance to sign in, but it's good to see so many people on the call or in the meeting, and some people I know and some people I don't know. So if I'm going to ask you if you would be willing in the chat room to go ahead and put your name and your affiliated organization in the chat room, then people will have a chance to see who else is in attendance here. That's pretty much the only way you get to see on these webinars. So yeah, just put your name and affiliated organization in the chat room if you so wish to be identified, and then everybody will get a chance to see who's there. Just so anybody is, for anybody who's interested, we are recording the webinar, and we'll have the recording available afterward. So that'll be something that can be downloaded from our website where you registered for the event. We have quite a few people who have registered, and they may be signing in along the way. So I'll just put another note up in the chat room and ask people to put names and affiliated organizations in there. So it's good to see we've got a couple people, more people from the Tall Ships America office, which is good. It's always good to see the staff on these. Fred Sitkins, thank you, Fred, for letting us know we were broadcasting. Inland Seas Organization. Doug Russell from UNOLS in Seattle. We've got Aaron from Clearwater, Hudson River Sloop Clearwater, Director of Operations. And we've got some other people who are in the chat, or who I can see as participants. Jonathan Kabak from Oliver Hazard Perry. Kurt Voss, who's been involved in a lot of different activities in and around the historic vessels. And let's see, Sarah Hirsch coming to us also from the West Coast in, I believe it's called Orange County. Sarah, if that's right. Yep, Orange Coast College in Costa Mesa. Captain Chris Couson from Brig Niagara. Good. So we're going to go ahead and do the same thing that we've done in the past, where we use the chat room. If you have anything you'd like to chat about that's not necessarily related to the webinar topic, or that is not a specific question. And if you have a particular question, put that in the Q&A box so that we can make sure and monitor that and get to those as specific questions for the panelists. Got also Laura Losey from Yorktown and Catherine Collins from Sound Experience. It's great. Thank you all for being here today. I really appreciate your attendance. We're going to go ahead and get started. Just welcome, and thanks for taking the time to spend a little bit of time talking about a topic that's very specific to our community, and also to the maritime industry. It's a matter, the Jones Act, a matter of great mystery and also relevance to all of us. And we really appreciate the fact that we've got so many the experts on the panel here to help us make some sense of it. Real quickly, I just want to offer a little bit about Tall Ships America. Most of you we know, and we know you, you know us. But I just want to tell you that we do have a couple of upcoming events that you might be interested in. We do have a Tall Ships Throwdown, no Tall Ships Challenge this year, no festivals, but who says sailors don't like a good competition? We have a throwdown that's just going to be a sail setting competition, as well as connecting with community around keeping the tall ships visible to all of our communities. Should be a lot of fun, and that starts next week with the competition and some vessel history lectures, and that information about that is on our website. And also we're doing that in partnership with Galveston Historic Foundation, and information is on their website as well. We are in the middle of a membership drive. So those of you who know us, love us, and would like to spread the word, please do so, and please join as we continue to serve the tall ships community around North America. So with that, there's probably other things we should be saying, but we're going to turn it over to the panel so we have plenty of time for discussion and plenty of time for questions and answers. And just welcome. And I'm going to turn it over to Chris Richmond, and he's going to make some introductions.
Thanks very much, Chris. Those of you who don't know me, I'm Chris Richmond. I'm with Allen Insurance and Financial, based here in Camden, Maine. And I've been doing commercial marine insurance for the last 8 or 9 years or so, and enjoying it very much, even with the lockdown and pandemic that we're suffering right now. But more importantly, joining me on the panel, we've got Brett Chase from Berkley Offshore. Brett's senior marine underwriter. He's over 20 years of experience underwriting marine risks. Brett's an active participant in the Massachusetts Mariners Club and sits on several panels yearly discussing marine insurance. He holds a BS in Business Economics from the University of Maine at Farmington. And Brett's been with Berkley Offshore for the past 4 years, and prior to that with Acadia Insurance for the last 16 years prior to that. Joining him also is Will Marioni, who's Assistant Vice President, Marine Claims at Berkley Offshore. Will has 25 years of experience in the marine insurance market, having progressed through various positions in both the broker and carrier segments. He holds a bachelor's in business management from St. John's University and a master's in education from Queens College, and has been with Berkley Offshore for the past 8 years. And finally, we've got Bob Murphy. Bob's a founding partner at the New England Admiralty and Insurance Law Firm of Holbrook and Murphy. Holbrook and Murphy was founded in 1996 and based in Boston, with attorneys admitted in Connecticut, Maine, Massachusetts, New Hampshire, New York, Rhode Island, and other areas on a pro hoc vice basis. And for the past over two decades, Bob has specialized in marine law and represents domestic and international clients, as well as their insurance and a wide variety of commercial insurance and maritime matters. Bob received his Bachelor's of Arts from Plymouth State College and his Juris Doctorate, cum laude, from New England School of Law. Bob's a proctor, member of the Maritime Law Association of the United States, and the president of the Massachusetts Mariners Club, and a frequent writer and lecturer on commercial insurance and maritime topics, and a hell of a guy as well. So guys, thanks very much for joining us. Chris, thank you for hosting this. I know it's been a topic of concern, and myself, along with any other marine insurance, or actually any insurance agent, starting in March, started fielding all sorts of phone calls about COVID. And obviously in the marine area, we had questions concerning Jones Act as well. And I can't think of a better group of gentlemen to try to answer the questions out there than what we have here. To start off, I think we're going to have Bob give us an overview of the Jones Act and talk about Made and Secure and Jones Act, and basically what that does. You know, we feel you can't hear it enough. So with that, Bob, it's all yours.
Thanks, Chris, and thanks for the introduction, except for the end. Felt like just the way I wrote it, so thanks for that. So very briefly on Siemens remedies, let's say. We need to think of this in historical terms, first of all, because that's what animates current maritime law. Historically, a crew member who became ill or injured in the service of the ship had very limited recourse. They were not, and they still are not, subject to workers' compensation. And under the old law, they couldn't bring a cause of action against their employer for negligence. So an injured or an ill seaman didn't have a lot of recourse. Congress reacted to what was perceived as a harsh result by passing the Jones Act, which we're going to talk about. And the courts responded by enlarging the protection for seamen under the general maritime law. So they're two separate things, Jones Act and general maritime law. Today, seamen, think member of a crew of a vessel, they enjoy three important protections. One, they can bring a cause of action for negligence against their employer under the Jones Act. 2, they can bring a cause of action for unseaworthiness of the vessel under the general maritime law. And lastly, they may be entitled to payments of maintenance and cure under the general general maritime law. So let's touch on the 3 just very briefly to kind of encapsulate our discussion. Like I said, the Jones Act allows a negligence cause of action. All of the ins and outs of the Jones Act are beyond the talk, and I know recently there was a wonderful talk just on the Jones Act, so I'd recommend that to everybody. But the takeaway here is it's a negligence cause of action. You have to show fault on the part of the employer. And the essence of the Jones Act is that the Jones Act seaman is a favored class of litigant. Their case is easier to prove than a landside analog. They have an easier time of it, which can be a challenge for the employer. So that's statutory. That's the Jones Act, a statute passed in Congress. Under the general maritime law, this is judge-made law now, not a statute. A crew member is entitled to a warranty of seaworthiness. The vessel operator has a non-delegable duty to provide the seaman with a seaworthy vessel. And if they breach that duty, the vessel owner is responsible for the damages it causes. Now, most people hearing this says, well, what's the big deal? My vessel's seaworthy, it's afloat. It didn't sink, but the standard is more than that. To be considered seaworthy, the vessel, its crew, the appurtenances, the equipment, they all must be reasonably fit for the intended purpose. So the standard is reasonable fitness, not perfection, not a ship that can withstand every storm, not the newest and greatest equipment, but reasonableness. Very important, especially in the context of COVID, the seaworthiness doctrine, fault doesn't enter into it. The vessel owner could do nothing wrong and still be liable for breaching the warranty of seaworthiness. For instance, if a perfectly good line aboard the vessel, you've bought it new, you've replaced it when it needed replacing, you haven't done anything wrong. If that parts and the line is determined not to be a fit appurtenance aboard the vessel and it hurts someone, you're going to be liable even if you weren't at fault. So, as you can probably see, under the Jones Act and the warranty of seaworthiness, issues of causation are going to be huge with regard to COVID, and that's because it's often difficult to, trace where the infection came from, et cetera. So a lot of the defenses we're going to see, and we'll talk about this later a bit, I think, is causation. And this leads me to the last seaman's remedy, which is maintenance and cure. Every seaman who becomes ill or injured in the service of the vessel, regardless of fault of the owner or operator, they're entitled to their payments of maintenance and cure. Maintenance is essentially reasonable expense for room and board ashore, and cure is reasonable medical expenses for curative treatment. So maintenance and cure, like on seaworthiness, operates regardless of fault, but more importantly for our purposes today, the seaman does not have to prove a causal relationship between their injury and their service aboard the vessel. It is enough if the symptoms just manifest while they're in the service of the vessel. So as you can imagine, this can result in substantial exposure under maintenance and cure because essentially the cost of medical treatment has outpaced inflation and can be quite expensive and can represent quite a bit of exposure for the vessel owner. With regard to maintenance and cure, it's an ancient doctrine, although recent court holdings have expanded its reach. And there are very few defenses to maintenance and cure. One is willful misconduct. Generally, that's a reasonably high bar, and we'll talk a little bit about that later. And 2 is knowingly, if the seaman knowingly conceals or misrepresents material facts, such as a prior medical condition. This is the so-called McCorpin defense. But but the point with Maintenance Secure, I think, is that the defenses to this are very limited, and we'll talk about later steps that the vessel owner or the employer needs to take to give themselves, whatever kind of defenses they can have to help us, if it does become a case, to marshal evidence and defend the case. So I think that's probably enough to talk about right now for a brief overview. Obviously, there's a lot of layers and a lot of nuances to a lot of this, but
Yeah,
that's probably a good framework for our discussion.
I think it's important to note that we would see crew claims come in, and it could be an illness, it could be, a strain, it could be something, simple as, the flu or something like that. And again, working on board the vessel really didn't cause that to occur, but they were employed at the time as a crew member, and so the policy reacted at that point. Obviously, with the pandemic, at first I reached out to some adjusters and said, how's the policy going to react? And adjusters came back in the positive fashion, but hence we've seen exclusions coming forward now from many different carriers all across the board, and there are different exclusion levels as well. And I think to touch on that, Brett Chase, what are you seeing now for exclusions out there?
Well, again, I'll just start off by saying that, make sure as an insured, you're checking your policy when you get your renewal. Here at Berkeley Offshore, we have started adding a COVID exclusion to our policy, effective renewal and new business. So there are different variations of the COVID exclusion. Ours alone is pretty much exclusive to a COVID related loss, whereas there are other forms out there that it's a communicable disease exclusion, which is a little more, this one here is the communicable disease exclusion. So a lot of companies now have started to add this as it's something that we can't really underwrite. It's not like a warranty on a policy that you're going to keep, your vessel seaworthy. I know Bob has touched on that, but so again, make sure you're double checking your policy. Most companies are not going to change anything midterm. I know we certainly wouldn't do that, but you will get a notice of policyholder from us, letting you know that there has been a change in your renewal. So actually, if you would excuse me for a second, my phone's ringing. I don't want to.
The luxuries of home office. One thing to notice or to make note of is, as Brett was saying, there are there are several different exclusions that I'm seeing come across the board. Berkeley Offshore is, as Brett said, very specific to just coronavirus. Other ones, such as the exclusion that Chris has got on the board now, this is American Institute of Marine Underwriters communicable disease exclusion. It's not just specific to COVID-19, it's to any communicable disease. So it's sort of a much broader exclusion at that point. Brett, one thing I wanted to ask, and just to help out you as an underwriter, this isn't really coming, these exclusions aren't coming from you. You're getting hired direct of, aren't you? Can you sort of explain how that happens from the reinsurance?
Sure. And again, sorry about that. I forgot to I muted my cell phone, but not my home phone. Yeah, so a lot of us companies have what's called treaties. So we are protecting ourselves in the event that there is a major storm or a catastrophe. So our losses are mitigated. So when we renew our treaty, we are in essence buying insurance from another insurance company to protect ourselves. So they, like our policies, will have exclusions and things they will and will not cover. So as companies' treaties come up and we are told that they are not going to cover any sort of any sort of COVID loss or communicable disease, we in turn have to protect ourselves by adding the wording to our policy, because in the event that there were, one port got hit with a couple hundred cases and there were millions of dollars of losses, that we would be able to at that point turn around and go back on our exclusion, or make sure that we have mitigated our loss like everybody else. So it comes down from the top. It's not necessarily just us being all, here we go, this has come up, we have to do this as a company. A lot of times it's driven by reinsurance and even higher than that.
You're offering buybacks, though, aren't you?
We are, and I think this gets touched on a little later. So we are offering limited buybacks of COVID. What we require is a very detailed plan in writing of what you as a vessel owner are doing as far as crew screening, passenger screening, face coverings, exactly what you are doing. So some of the ones we've seen have been very detailed, and we underwrite each one individually as well. So, another thing to keep in mind is you also have to make sure as a vessel owner, if you're operating at this time, that you are following your state and federal guidelines with requirements as far as face coverings, number of people allowed on the vessel. So that's what we are looking for if we offer a buyback, is to make sure, whether it be taking temperatures, a questionnaire for your crew, requiring that everybody wear face coverings while on the vessel, announcements as to social distancing while the vessel is underway, and all that stuff.
Yeah. So what I've seen in the industry is sort of limited buybacks from some companies for a nominal fee, and then a full buyback as well. And generally the premium on that is, what I'm seeing is 10% additional premium based on what the current protection indemnity premium of the policy is at that point. So it does cost something, but I think it's important to remember that just because it's not covered on the policy doesn't mean you don't have to pay for it. You still have to pay for it if a claim comes up. And these COVID exclusions are hard and fast. If there's exclusion in a policy, as an insurance agent, you'll learn real fast. If it's excluded, companies typically don't cover it. So it's something to pay attention to. These, as Brett said, and I'm seeing it as well, as policies renew or new business, almost all the companies we're working with are seeing COVID or communicable disease exclusions out there. And it's just something to pay attention. But you can negotiate, hopefully, a buyback with your underwriter at that point. So keep an eye out for those, and certainly ask a question about trying to get that coverage put back on, because it's extremely important to have that. One thing I wanted to say is if there's, there are limited alternatives out there in some ways for crew health care plans. That's really, and when I say limited, that's really geared towards specifically just the cure part. It's not going to do anything if there's a Jones Act claim made against you. And I can't think of any alternative to having a coverage on the policy. I don't know, Will or Bob, is there anything out there? If somebody doesn't have the coverage on their policy, are they just paying out of their pocket at that point if there's a claim?
Right. If they're not covered for a COVID claim,
Right.
they're going to wish they were, because
Yes.
On the Jones Act, like I touched on earlier, the seaman's a favored litigant. So a person hurt on shore, they typically are limited to workers' comp, right? There's no pain, there's no suffering, there's no the general damages that often drive a verdict. The shore based employer, doesn't have to face all that. The Jones Act employer is on the hook for all that if you can prove negligence. The maintenance and cure, Chris, like you say, there's not much you can do for the maintenance part of it, but the medical exposure, you can imagine a situation where someone's hooked up to a ventilator or something like that, and that's going to be a big ticket item. That's a lot of exposure for the vessel owner or operator. And the kind of ways around the maintenance and cure, for instance, you could pay, if you, as the vessel owner, paid for every single person who works on the ships health insurance, 100%. Well, that could be viewed as a way to defer your cure obligation, right? You're funding any medical bills they may have, but that's a lot more expensive than the buyback typically.
Yeah. Yeah. So again, as your policies renew, have a chat with your agent, and hopefully they'll notify you if there is an exclusion. But there are hopefully ways to get some coverage added back onto that. Speaking of coverage, one area that I fielded a lot of questions on was lost revenues due to all this. And Will, what do you have to say about that?
Well, unfortunately, loss of earnings for the vessel itself, in order for that to be a payable claim, it has to result from a physical damage to the hull, or an engine damage type claim. Otherwise, there is unfortunately no coverage for loss of earnings. And most loss of earnings endorsements that I've seen, they have communicable disease exclusions on them. And they also have exclusions for shutdown of your business due to a governmental entity decree, which has obviously happened during the pandemic. So the only way it kicks in is if there's a physical damage to the vessel itself.
Right. That was a lot of hard conversations I had with vessel operators and owners early this year, it was a tough one.
Yes.
What about current claims? I know we had a conversation earlier. You really haven't seen any claims come across your desk so far, though, have you, Will?
Luckily, no. But I'm sure down the road that they'll be there. But just one thing I wanted to, expand upon from what Bob said earlier. He used the term "in service of the vessel." We talked about there would be a valid claim if the condition manifests itself on the vessel. You're also considered in the service of the vessel in certain situations where you're not actually on the vessel. For instance, if you're on shore leave, or if you pull into a port and you have to go get supplies, let's say, you're still on the voyage. So you're still considered in service of the vessel in those situations. So I wanted to expand upon that a little bit.
Okay.
And that's a good point, because that could be frustrating to a vessel owner where, there's some shore excursion or whatever, and some person gets themselves into trouble somehow, whether it's COVID or something else, and then you kind of own it. And I think when you talk with a lot of vessel owners, it doesn't feel fair to them, especially the maintenance and cure component of it, where the defenses are so limited. So, there's case law where one of the famous ones, a guy on shore leaves jumping out a brothel window and he injures himself, and they have to pick up the tab for the maintenance and cure. So it's an expansive exposure.
But if you do have a case that manifests itself and you have a claim, the most important thing to do right away, at least as far as I'm concerned, is to, if at this point I would assume it wouldn't be as a serious situation and the crewman would be at home, but I'd want to talk to them and give them, my contact details, so he has that when he goes to the doctor, because the doctor's going to want to know who's paying. And basically, that's the first thing I would discuss with the crewman. because the medical provider is going to want authorization from the insurance company, and assurances from the insurance company that we will be paying and where to send the bill.
Speaking of bills, what if there is an outbreak on board a vessel, and they have to come in and get a third party come in and do a deep cleaning to decontaminate the vessel? Is that covered under the policy, assuming that there's no exclusion? They've bought back the coverage at that point.
But yeah, but that's, I guess, open for debate at the moment, because you can possibly argue on the whole policy that you have a sue and labor situation to order to make the vessel get out of the unseaworthy condition that it's in, being contaminated. I don't know, Bob, if there's been any other type of legal decisions on something like that, maybe with the cruise lines, with the with all the viruses that go through those vessels.
Right. So on all these things, right, the facts matter, right? So different facts. And then with the policies, we're talking generally whether there tends to be coverage, tends not to be coverage, but obviously you have to look to the policy itself. Sue and labor is a concept, like you say, Will, we tend to think of that in terms of a hull policy or a cargo policy, right? And it's the insured's obligation to protect the underwriter's interest, and in turn, the underwriter to pay the costs that the insured took to prevent a greater loss. But that has very, very, very limited application in the P&I side of things, right? So if there's all sorts of things that a vessel owner has to do to be able to put to sea that the insurance doesn't pay for. So if a surveyor makes a recommendation that you've got to, upgrade fire extinguishers or whatever, or if the Coast Guard makes recommendations or demands with regard to the COI, those don't tend to be covered by insurance. They tend to be an expense of doing business. So, you'd have to really look closely at the facts of any situation, and you'd have to, really carefully look at the language of your specific policy. But I think you'd have a real uphill battle there. You'd be a real uphill battle, I'd say.
I've got a question from one of the viewers concerning service to the ship. And the question is, are you still in service to the ship if you don't live aboard the vessel, but come to the ship to work on day programs and you live at home?
I would say that your role is defined there. You're on the vessel for the day, and that's it. So when you're back home, you would not be covered. Because that seems like a specifically defined role, which could be interpreted as just, not being in service of the vessel. You're just going to your office and coming home.
So
I would agree with that, Will. And you see that a lot, for instance, with the fishing boats, where, you made the previous trip, you're probably going to make the next trip. You're in home in between those trips. Like Will says, it's specifically defined, and therefore you probably aren't. But this is probably a good segue into the idea that with many small vessel owner and operators, they probably could do a better job documenting things, right? So many of these operators do a wonderful job of creating a culture of safety aboard, and that's the most important thing. But then when the lawyers do get involved and we're asking to marshal evidence, where's the documents, where's the proof? It just doesn't exist sometimes. So like Will says, the example that was given, that's a pretty defined service, right? So that in between, you're probably not in the service of the vessel, but a document that the vessel owner creates that spells that out would be helpful, because, injured claimants with a gun to their head, they're going to allege all sorts of things. They're going to say I was, and you've got to defend it even though you don't think it's true. Documentation helps.
one thing I constantly tell my clients is that if a crew member comes with an ailment or an injury, to report it. That way, the vessel owner isn't making the decision if it's a claim or not, I always say, let the adjuster make the claim, make the decision.
Yes, agreed.
It's just a slippery slope, and they can, I think, run into some difficulties down the road if that injured crew member decides to pursue the claim and, could formulate into a Jones Act claim at that point, Bob. Would that be true, or would they be able to sue the vessel if the owner of the vessel didn't submit the claim, decided on their own that it wasn't covered?
Yeah, the vessel owner doesn't want to be making coverage decisions because, there's a difference between a covered claim and a specious claim, right? You see ridiculous claims all the time. Claims that you think are phony, claims that you think didn't happen, claims that you think happened somewhere else. But those are still covered claims, right? You're still going to get a lawyer to defend you, and you're going to need it, because anyone who reads the newspapers knows claims that on their surface look silly, often can, if you screw them up, they result in big verdicts. So yeah, I think when someone makes a claim, you want to pass that along and then let the insurance people, the claims managers, the lawyers, they'll do their thing. Your role, to me, as the vessel owner, you got to give us something to work with. And I saw there was a question, Chris, on documentation, for instance. I mentioned earlier that willful misconduct can be a defense to maintenance and cure. But a lot of people don't have any kind of employee handbook or any kind of posted notice that informs the crew member of what's considered willful misconduct. I mentioned earlier that withholding material facts, such as a pre-existing injury, that can be a defense to maintenance and cure, but you don't withhold it unless somebody asks. So it's interesting to me, the Coast Guard for an able-bodied seaman has a detailed medical questionnaire about pre-existing medical conditions. Very few small vessel owners use these questionnaires, which could be a defense with regard to maintenance and cure. And there's not very many defenses, so you have to give yourself the leg up that you can.
Yeah,
And as far as reporting, not reporting or not reporting if you think someone's sick, or in any instance, and not necessarily medical situations, but in any instance where you feel you may have a potential claim, you should always report it, because what that does, it protects you, because then, I can't take a late notice defense against you because we're notified. So anything, and no matter how trivial that you think could arise to a claim, you should report.
One question I get from clients, actually, and Brett, you can address this, is if I put a bunch of claims in, that's going to affect my premium.
Again, I'll speak for myself. I can't speak for all underwriters and companies, but if it's just a notice only claim, because we see them a lot, I myself do not hold those against the insured. We tell our insureds all the time when we talk to our agents, and pretty much any panel we're on, even when we're down in the tall ships panels. Again, the more details you can get, whether you think it's a claim or not, to get to your insurance adjuster, and again, it can be notice only, but you've started the ball rolling, you have witnesses, you're not trying to piece something together last minute and late, where you may not actually be at fault. So again, if it's not a paid claim, I certainly don't hold it against the insured. We know that things are going to happen on a vessel that are covered, and some that fall below a deductible or actually are nothing at all. So don't let your insurance premium be the driver of, well, I don't want to submit this slip and fall. The person told me they were fine, and then 2 or 3 months later, you get a notice from a lawyer that their back is now, their back injury is, or neck, and now we're trying to piece together, or Will's trying to piece together what happened 2 to 3 months ago on a voyage, and you have no record of witnesses who saw said person maybe not even slip and fall. And again, but you have names and numbers of contacts, and Will has it and can adjust it accordingly.
I've got another question here from the audience. Does Jones Act cover the quarantine period prior to sailing a ship for the crew members? The crew members arrive, they've got to quarantine for 2 weeks, I would think, before the vessel gets underway. Is that quarantine period covered?
A pre-quarantine period, no. But however, if let's say you have a individual who's not living in your home port, let's say he travels from out of state, comes down with it while he's on your vessel, it has to be quarantined. He can't go back to his home state. He can't leave that state. If he has a place to live, he's going to have to quarantine. So in that instance, I believe we would entertain that under the cure aspect of maintenance and cure.
I think that's exactly right, Will. The way to think about P&I in general, which is what a lot of vessel owners have, right? That's the ship's legal liability to others. So these kind of preventative quarantine before you come to work, legal liability hasn't attached, right? Making people take precautions before they come to work. There's no legal liability of the ship. But once the person has COVID and they bring the maintenance and cure, they'll bring a Jones Act claim, probably. Then it becomes part of consequential damages. Under the Jones Act, which is the negligence cause of action, if they're able to prove their case, they're entitled to those special and general damages they can prove, and that's pretty broad. So I would say that would include these kind of consequential damages.
But, not the presidential suite at the Marriott. Be reasonable.
So what is the going? Is it $45 a day for maintenance? Is that?
Generally in a city area, roughly 35, rural less, depending on where they live.
You have to be very careful. When people talk about what's the going rate, most often goes back to when seamen were in unions and had a collective bargained rate with regard to maintenance. The maintenance is the actual reasonable living expenses comparable to that you would have enjoyed aboard the ship. So lots of human resources departments, they want to treat everybody the same and say land-based workers' comp, you would treat everybody the same. It's some percentage of your average weekly wage that you'd be entitled to. But with maintenance and cure, most people are going to be different. A seaman who lives at home with their parents and doesn't pay rent is entitled to nothing on maintenance because they haven't actually incurred the expense. Other people will have higher rates of maintenance, and typically you'll get them started off at $35 or $40, whatever it is, right? Well, but then that's typically followed up pretty closely with, here's my actual expenses.
Right.
And you look at the ones that are covered under the doctrine. Some aren't, some are. In different jurisdictions, you can argue, cable, cell phone, are they part of living expenses or not?
I usually delineate between if you're living in a city or in a rural area because it's cheaper to live in a rural area.
Sure.
Like a maintenance rate in Miami is going to be a heck of a lot higher than it would be up in a rural area of Maine.
That's for sure. There's another question here about vessels ceasing to operate. Brett, have you seen, what's your experience across the board, not only with tall ships, but in commercial vessels as well? Are you seeing a lot of vessels not operating due to the pandemic conditions out there?
I'm primarily the book of business I primarily underwrite is here in the Northeast. So until states started opening up, passenger vessels were all shut down. Workboats, fishing vessels were deemed as essential, so they were allowed to fish. So they were out and going. But the majority of my book is, again, passenger vessels, so they were shut down. A lot of them have reopened to, in a limited capacity as states started opening up restaurants, and then passenger boats were, a lot of them were July 1st, I believe, or, here in Maine and New Hampshire. And so passenger boats have started. Some have opted to shut down completely for the year because it didn't make sense for them to operate at a limited capacity while hiring a crew to come in. So it's really split along the lines of passenger boats and then your fishing / work boats that were allowed to continue to work even during the government shutdown.
Yeah, I've sort of seen that with the vessels that I insure as well. A lot of the overnight vessels still have their covers on from last winter, whereas a lot of the day sail vessels were able to squeak out somewhat of a season here. Well, here's another question. Will the P&I policy respond if a crewman's sick with COVID, but there was no sign of infection while he was working on board the boat? How does that? I think you might have touched that a little bit earlier.
Yeah,
but
basically, there has to be a signal or a sign that it manifested while I was on the boat. Like if the crewman just comes up to his captain and says, "Hey, I don't feel well. I think I have a fever. I'm achy." He goes to the doctor and he has COVID. Yes, but if he leaves the vessel that day without any sign of anything, then he calls, his owner, or the vessel owner, a day or two later and says, "I have COVID," but we're not going to respond to that.
Yeah. Again,
Chris, that would be heavily fact dependent as well, right? There are cases, think of an asbestos case. Some person working on a ship that was loaded with asbestos might later come down with mesothelioma or something like that, right? So the symptoms might, so I agree in general with what Will just said, but you can picture a scenario where symptoms do not manifest themselves while you're on the ship, but that you did pick it up on the ship. And my understanding of COVID, for instance, you could get it, but it wouldn't manifest itself to some time later.
Right. I mean, if you had a condition on the ship that, or previously,
Exactly.
in the first few days, let's say, and then all of a sudden he gets down with it, someone else comes down with it off the service when he's not working, then it's a gray area. You may have to consider the fact that there's already an outbreak on the vessel. Maybe he caught it there. So in that scenario, I would respond.
Exactly, and that's what I was going to say. It's really a matter of proofs, and a lot of this might even be expert testimony. There is a feeling, I kind of agree with Will, once you get him down the gangway without a problem, you don't own him anymore. And a lot of vessel operators use a sign-off. I did not witness any injury. I did not come down with an illness while on the ship. And a lot of them, you sign off on something like that before you pick up your check type of thing.
So what I'm hearing though is that it's still very fluid in COVID. I mean, Will, you haven't seen many or any claims. There are a few claims that I've seen through different marine periodicals of Jones Act or maintenance and cure claims out there. But keeping the protocol set up as Brent was talking about, just to keep a vessel and the crew and passengers safe. But most importantly, getting the reporting in there as well for the owners and operators. If you feel you've got a claim, contact your agent and let the ball start rolling there. Don't take it under your own control at that point.
And another possible exposure could be if you're running a passenger vessel and you've had maybe documented cases a while back on your vessel and you're starting to sail again and you have passengers aboard and they come down with it and they sue you because they say, "I caught it on your vessel." Okay. I haven't seen that scenario yet, but I'm sure it's going to happen at some point. And that's where it's important as a defense, as a vessel owner, to make sure you understand the federal and state guidelines for your operation. Follow it to a T and even go overboard. It's not an absolute defense, but it is a defense.
Yeah. Did you have something, Chris? I saw.
Yeah. I thought I'd kind of follow this up about and maybe I missed it when my internet dropped out, but the disconnect between the communicable disease exclusion and, you know, the obligation that the owners and the operators have to their crew. And if there's a disconnect between those two, is there, you know, that creates a big strategic problem for our fleet. And I'm wondering if that's been addressed or thought about, or how is that, you know, is there, you know, governmental kind of buy-in, sign-in to any of these things that bridge that gap?
No, you see this a lot. You see a lot of marine operators that either don't have coverage or they're underinsured. You know, I'll get a case in my office where, you know, there's multiple deaths because the vessel sank or something. You know, they have $250,000 worth of coverage and legal fees come out of that.
Right.
That's a tough situation to be in. You've got claims. Unlike, say, auto in the state of Massachusetts, there's no real requirement that you buy insurance necessarily, right?
Right.
So you've got operators out there, you know, someone who might own a small lobster boat or whatever, and they may not have any insurance, or they may have very limited insurance. And if you think, especially in marine, the claims come, let's face it, the most important thing, right, is to be a safe operator, to embrace the safety of a culture, to take these kind of COVID precautions seriously, and hopefully you don't have claims. And I hope when I see people that I represent, I'll say, next time I see you, I hope it's over a drink, you know, not in court. But unfortunately, you can do everything right. In the marine environment, there will be claims. And your first line of defense for that is to have adequate coverage. Because if you don't, the claim doesn't typically go away. And if you don't have yourself set up right, if you don't, you know, the vessel itself can be on the hook for it, which is kind of the romantic notion of maritime law that the vessel's almost a person. So that would give rise to a maritime lien. Or depending on the situation, you yourself, your company, you yourself personally maybe could be liable for it as well.
So it's basically self-insuring for communicable diseases that are not being underwritten by the insurance companies. Am I getting that right?
Well, you can buy back the coverage, though.
And buy back the coverage.
A lot of companies offer the buyback. Not all of them do. And so that's an important conversation to have with your agent as your renewals come up. And as Bob mentions as well, you know, coverage limits as well. You know, $1 million isn't what it was 10 years ago or 20 years ago. $1 million can go pretty quickly, especially if you include defense costs as well. They can rack up as well as part of that $1 million limit. So take a look at what you're comfortable with a loss. Excess policies go over that $1 million. They're not cheap. We've seen a rise in premium in excess layers of liability, but it's going to be a lot less expensive than if you've got a serious claim and that $1 million on your policy is chewed up. You're still responsible for the remainder of that claim.
One other question that came up in the chat box, and again, apologies if this has been answered, but it says, can you explain how the Jones Act protects non-sailing winter crew, if at all, during the winter months when the crew stays on land and works all day on maintenance of the boat? So this says it's a winter maintenance or any kind of maintenance kind of question.
Mm-hmm.
Yeah, so I understand the winter maintenance situation. They would be in service to the vessel once they're on board doing the maintenance. Yes. And once they come off, no.
Okay.
And just to follow that up again real quick, Chris, is to make sure that an insured has the proper amount of crew coverage on their policy. You know, if they only told us that they're insuring 2 crew, but maybe during the winter they actually employ 4 crew to work, we just need to make sure that we have proper crew coverage on the policy. So that's again something they should discuss with their agent when they get their policy. Double check what their crew count is for coverage, and then talk to their agent if that needs to be altered before it's before they try to submit a claim and then there's an issue with crew count.
Yes, it's not an issue, it's a penalty based on the claim.
And with the seaman status, the Jones Act seaman who's working ashore, again, documentation is crucial. Under the Jones Act, they don't tend to sail in and out of coverage, right? So a Jones Act seaman doesn't lose the law's protection just because they step ashore, right? It's a status-based thing. Now, at some point, so for instance, on a fishing boat, they may do gear work the day before they go out to sea. They're still Jones Act seamen doing that gear work, even if the gear work's ashore. And then they go to sea. They don't sail in and out of coverage. But with many people, especially a seasonal operator, your job description changes. It's not that you're sailing in and out of coverage. If the vessel isn't operating and you're just spending your time doing something else, arguably you're not a Jones Act seaman, but the injured person's going to want to be a Jones Act seaman because they're a favored class of litigant. So they'll claim they are, maybe. And then someone like me is going to ask the vessel owner, well, give me the documentation. You know, they'll say, well, the job changed. We tie up for the winter. Okay, show it to me. Lay it out for me so that I can explain this to someone else, a judge or a jury. In a lot of times, the documentation's missing. So you can do yourself a big favor with, you know, most vessel operators, they're great operators and they don't, you know, they're not paper pushers, but it's part of everybody's job now.
So another question that is really important in our community, obviously, is about volunteers working as crew members. And particularly as you start thinking about maintenance, winter maintenance and things like that, there's a lot of volunteers who have that very specific role of being part of the ship crew, but not paid. Can you speak to volunteers, how they're treated with respect to the Jones Act and maintenance and care?
Fred, how do you view volunteers from a coverage point of view?
Traditionally, volunteers, again, I am only going to speak for myself and our company. We actually cover them as passengers and not as paid crew members entitled to Jones Act. So we give them status as a passenger on the vessel. Again, because and Bob can speak more to the, you know, employment part of Jones Act, but volunteers we typically cover as passengers.
Yeah, I have seen other underwriters from companies who would depending on what the volunteers are doing, but would classify them as crew member status. I think it's important to however you see your volunteers, have the conversation with your underwriter or your agent, and then the underwriter at that point, and just to establish with that company how they view those volunteers.
There's 2 points on that, Chris. One, the injured person makes the first claim as to what their status is. So a volunteer that you don't think is a Jones Act seaman, but let's say the person's aboard the vessel, tending lines, trimming sails, that sort of thing, undoubtedly they will claim they're a Jones Act seaman because that's a favored litigant. They get a better deal in court if they are. A true volunteer is not a Jones Act seaman because Jones Act needs an employment relationship. You sue your employer. And a true volunteer isn't really thought of as a member of the crew, but just paying them isn't the determinative factor, right? Just like Chris, if you had an unpaid intern in your office on land, you're saying, hey, they're not an employee, I don't issue them a W-2. If they get hurt doing something at work, you can expect a workers' comp claim. Same here with the volunteers. If just because you're not paying him, that's one indicia that they might not be an employee, they might not be a member of the crew, but it's not really the most important indication. If you're controlling what they do, telling them what they can do, telling them when they can show up, when they can't show up, you could well be thought of as an employer, even though you're not paying these people, and then you'd be staring down at Jones Act exposure.
Great. We got just one fairly quick one, which is, do you have any kind of example of a sign-off form for crew? And that's something we can return back to and see if we can come up, if anybody has an example of they're leaving the ship, they're signing off saying, you know, I'm leaving and I'm okay, so don't worry about me. But so that might be one we can come back to. But the other one was, if a ship is on the hard, the question is, isn't that USLNH? And I'm not familiar with that acronym, so I don't know if you all are.
That's the Longshore Harbor Workers'
Longshore.
Compensation
Right,
Act.
that's right.
And,
Okay.
and that's essentially, the law divides maritime workers into two categories: ship-based seamen,
Mhm.
essentially land-based workers, even though they may spend most of their time on a ship. So think of a longshore worker who's unloading a ship. They may spend all day on a ship, but they're not a member of the crew of the vessel. Therefore, they would not be covered by Jones Act. Their claim would be under the Longshore Act. The problem that you have, though, is it's really not our determination. You've got tons of cases where these workers fall into a gray area, and they're going to make the claim not based on what they really are. They're going to make the claim based on where they think, I mean, their lawyer will make the claim based on what they think the best case for them is. So you might find yourself defending a Jones Act case that you thought was a longshore case, and you may be right, but it may take you a year through the courts to prove you're right.
Basically, in order, another, I guess, qualification for Jones Act, to be a Jones Act seaman, it would be you have to spend at least 30% of your time in the service of the vessel. So that's always, a lot of times you get into disputes between the longshore carrier and the P&I carrier about how much time the individual spent on or offshore.
Mm-hmm.
USLNH coverage as well. I'll recommend clients to just add that to their workers' compensation policy if there's any question. Because if you don't have the coverage, the individual could still put up a claim, a USLNH claim, and you don't have the coverage, it's not going to respond at that point.
Well, we are at time, and I really appreciate that. That was a really good discussion, a lot of good information, and appreciate very much. Chris, do you have any parting comments?
I guess my parting comment is when that policy comes in your mail or electronically, just take a glance at it, but have a conversation as well with your agent, because the more they know about what you're doing, the better off you're going to be. And you know, insurance agents can't read your mind. We might have an idea of what's going on, but you know, just don't be afraid to get on the phone or an email to the agent and just keep them up to speed with what's going on, just to help keep you as protected as possible.
Great. Well, again, I just want to say thank you very much, Chris and Allen Insurance, for putting this together, and for our panelists, Bob, Will, and Brett, for talking us through some of these things, and maybe raising some more questions, and then that we'll have to come back and answer at a future time. So appreciate everybody else showing up and being here and being part of what we're doing here with Tall Ships America, bringing our community together. So thanks very much, and everybody have a good day.
Thank you.
Thank you.
Thanks.